Hello and welcome to the Center for American Progress. My name is Winnie Stackelberg and I'm the Executive Vice President of External Affairs. I'm so delighted that you all could join us today. In our recent report, Reviving Antitrust, CAP highlighted the concerning indicators that the economy has grown far too consolidated, with more power being concentrated among the largest firms in America. This is in no small part because of the conservative assault on both government and the middle class. This assault has played out not just in the courts, but in antitrust enforcement practices of the Department of Justice, the Federal Trade Commission, and at a wide range of federal regulators and in the halls of Congress, where the view that big meant more efficient has dominated for far too long. Since the early 1980s, conservative legal thinking, embodied in Robert Bork and Antonin Scalia, has sought to dismantle the ability of government to protect consumers, workers, small businesses, the environment, people of color, basically all of us ordinary folks, from the abuses of markets and large corporations. Unfortunately, the Trump administration is going precisely in the wrong direction. Trump has appointed billionaires and ideologues to his cabinet that seek to strip the government of these tools to protect the public. He has appointed a chair of the Federal Communications Commission that seems perfectly comfortable with rising industry consolidation and limited privacy protections. And he has nominated a Supreme Court justice who promotes a legal philosophy aimed at enabling even greater concentration of economic power. So what does this mean for ordinary Americans? Market consolidation means sky-high drug prices and airline tickets. Small businesses shut out of markets, lower wages, less innovation and choice, and even broader trends like the deindustrialization of the Midwest. In fact, I don't think it's an exaggeration to say that such concentration of economic power plays a big role in why conservatives in Congress want to pass massive tax cuts for corporations and roll back Wall Street reform while ignoring communities in need like Flint, Michigan. That's not something ordinary Americans sitting around the kitchen table want to see more of. Given these threats, we need lawmakers like Senator Amy Klobuchar, the senior senator from the state of Minnesota, who will be speaking today about a critical piece of this puzzle, the need for vigorous antitrust enforcement in an era of increasing market concentration. In a town like D.C. that is not known for its friendliness, Senator Klobuchar brings a refreshing dash of Minnesota nice. But do not mistake her collegiality for softness. A former county prosecutor and the first female senator from Minnesota, Senator Klobuchar also brings an iron-range toughness to Washington. The daughter of a journalist and public school teacher, Senator Klobuchar is a fighter for middle-class families in Minnesota and across the nation. As the ranking member of the Subcommittee on Antitrust, Competition Policy, and Consumer Rights, the senator has long been a fierce advocate for competitive markets that promote sustainable and robust economic growth. From railroads to drug pricing, Senator Klobuchar has been a consistent fighter for lower prices, higher quality, and fairness for small and growing businesses. We need more leaders like her in Washington. Please join me in welcoming the Honorable Senator Amy Klobuchar.
Well, thank you so much, Winnie. We were pretty excited to walk in and see this sold out crowd for an antitrust discussion. Michael Kadish, who's my antitrust counsel, said it's the best day of his life. So there you go. They're far in between. But it is wonderful to be here with all of you. And thank you, Winnie, for your leadership, and Center for American Progress for all that you're doing. Before I was a senator and before I was actually a prosecutor for 8 years, I was a lawyer. And at one point, early on in my career, my client that I actually did the most work for over the years was MCI. And this was at a time when they were a scrappy company that was taking on the Bell companies and getting into the market. And actually, eventually, when I was representing them, trying to create some competition in the local market as well. And it was truly an exciting time to be representing a young, hungry company. MCI's scrappy lawyers viewed themselves as cowboys of sorts. They were fighting for consumers and lower prices. They were taking on the local telephone monopolies across the country. And one of the stories I remember I told at one of my opening arguments at a very exciting regulatory hearing was recalling that when Alexander Graham Bell developed the telephone, when the whole system started to work, he said those historic words. Does anyone remember what they were? "Come here, Watson, I need you." Okay, this is like lore of telecommunications. Well, when you get fast forward now to MCI in the last few decades, and they were finally getting ready to connect the first communication between St. Louis and Chicago. And one of their main guys, when this great moment occurred, he actually said the words, "The modern day 'come here, Watson, I need you,' was, I'll be damned, it actually works." Okay, but we have to know this. Without antitrust law, MCI would never have worked. MCI took on Bell Operating Company and AT&T and ultimately broke up that monopoly, lowered long-distance prices for consumers across the country, and revolutionized the telecom industry. Now, I know that antitrust law may not make front-page news or even capture the attention of all our lawmakers at any one moment, but it's important stuff. It's consequential. Look at even the newspaper over the weekend. South Korea. The president there recently impeached based in part on allegations that she participated in a bribery scheme that ordered government support of a merger. Or here in the U.S., the Nixon administration concluded during Watergate that the best way to intimidate the nation's three major television networks was to keep the constant threat of an antitrust suit hanging over them. And we all know how that ended. I think the American people intuitively understand that there's too much concentration in this country, even if they don't always describe it that way. In fact, 2/3 of Americans, including a majority of Republicans, have come to believe that the economy unfairly favors powerful interests. Even as our economy has stabilized and grown stronger, it's easy to see why people feel that way. You know, every year I visit all 87 counties in my state. This is something that I know Chuck Grassley does, and Chuck Schumer does it. And Chuck Schumer actually gave me the idea to start doing it, although I later found out that after years of doing this, he had an election, and he won every county except his smallest one. And he went to his chief of staff, said, "I don't understand it. That county's so small. I practically met every person in that county." And the chief of staff said, "That was the problem, Senator. That was the problem." But what I have found is that visiting all of these counties really gives me a sense of where people are in rural America in a way that I don't think you can get by just looking at newspaper clips or talking to your staff. And just in the last month, I was in 20 rural counties at farms and at everything from a Ducks Unlimited gathering of 400, mostly guys, to a LeSueur County township. And I can tell you what you see out there, that people are still struggling economically, hard to pay for internet, hard to pay for prescription drugs, hard to get that loan if they want to start something new. And they want common sense solutions. And that's why when you look at the rural economy, net income, 50% of it was 3 years ago for small farmers. That's a fact from the Farmers Union. Poverty rate for kids in rural areas is actually 4 percentage points higher than in urban areas. So this is real. And no one gets affected by this economic concentration more than if you're someone out in places that have less choices and less competition. And so strengthening that rural economy for me means not only doing something about prescription drugs and getting broadband out there and passing the Farm Bill, but it is also making sure that we have actual competition and that we vigorously enforce our antitrust law. So if you don't think that major mergers, whether it's ag or cable or healthcare, impact people, especially in places where there's a bare margin on costs like rural, I think those numbers I just gave you are all the evidence you need. And that's why this antitrust enforcement is so important. So some people may ask, what does a strong economy have to do with antitrust? And the answer is everything. Let me repeat that. Antitrust has everything to do with our broader economy. You've heard much of this before. When companies are allowed to compete, businesses can offer the highest quality good for the lowest possible price. That is capitalism. But what I want to emphasize is that talking only about antitrust in the way of the prices is oversimplified, because antitrust enforcement affects more than the prices that people pay for the goods that they buy. We now have evidence that competition fosters small business growth. Because if you just have big people dominating, it's really hard to get in the market. That it reduces inequality, right? Because the people that are most affected by these high prices, are the people at the bottom of the income scale. So they're going to be most affected if you have concentration. And that also you have a decrease in innovation when you have too much concentrated power. And that's something I'm going to come back to. I think it's really, really important. Yet, what do we see coming from the courts? Well, in the last few decades, the Supreme Court cases that maybe one of our panelists will discuss that, Trinco, Credit Suisse, Legion, among others, have actually raised barriers to the pursuit of antitrust cases. So our Supreme Court nominee, as you probably know, is an expert on antitrust, and I think it's more than important to pursue this in the hearings coming up, what his views are on the trend of the court and what's been happening to antitrust law in recent decades. So let's go back to why this matters. Concentrated interests make it nearly impossible for entrepreneurs and small business owners to compete. Firms with fewer than 20 workers make up 90% of the businesses in this country. So you can imagine if you start having all this concentration, you're going to really be taking a gouge out of the American economy. When there are 8 or 10 competitors, now this gets to the innovation argument. Well, they're going to compete to innovate, right? They're going to compete to offer the next best Fitbit or whatever else. I'm just showing that off again. But when you only have 1 or 2 firms, that is not going to happen because they don't want to innovate. They're happy with the status quo. Why do they want to have innovation? So think of your cable company and the cable box. No one liked the cable box, but for years the cable company made no modifications and continually increased rental rates. Recently, competition like Apple TV and Roku have improved the viewer experience and expanded choice. Competition drives innovation. If that's too technical for you, how about beer? For years, there were a few dominant carriers, right, in the beer market. They sold the similar mass market beer. We all know it, see it in the Super Bowl ads. Well, by 1978, there were fewer than 50 brewers nationwide. Then across the country, entrepreneurs started what we call the craft brewing revolution. By the way, Where were the jobs? The jobs for those, they were in America, right? Because they were small craft brewers. They tended to use more American ingredients. They innovated, they increased choices, and they improved quality. Today, in my state alone, we have over 70 craft brewers, more than the entire country had back in 1978. Now, I'm not going to go into the nerdy topic of the fact that some of the big guys are now trying to buy all the small guys, and some of the antitrust concerns we have there, and why we had our beer hearing, which was the most widely attended antitrust hearing in the history of America a few years back. What did we call it? Oh, the beer-hemoth merger. Yes, I remember. That was pretty witty. We really have to work hard in this area to make this exciting, but I'm trying to make the case for you today that this is not only important, but it's cool to talk about, because it's all about what's going to happen with the economy. Research suggests, as I noted, that concentration increases income inequality. Firms with monopoly power raise prices, taking money from consumers and putting it in the pockets of owners and employees. The consumers who spend money far outnumber the owners and the employees who gain it, all of which contribute to inequality in the country. So we have to recognize the broader benefits of antitrust enforcement, especially today. Now we're going to get to the facts of the current state. Since 2008, American firms have engaged in $10 trillion in acquisitions, and over the last 5 years, there was a 50% increase in mergers reviewed by the FTC and the Department of Justice Antitrust Division. There are signs of anti-competitive concentration everywhere. As former chair and now ranking member of the Antitrust Subcommittee, I've raised concerns about these mega proposals during the last few years. Take, for example, Comcast's failed merger with Time Warner. As we pointed out at our Senate hearing, if the merger was approved, the combined company would have controlled 60% of the country's high-speed broadband customers. Or the failed merger between Norfolk Southern Railway and Canadian Pacific, something I took on immediately after it was announced. Even without the merger, 90% of freight traffic is handled only by 4 railroads. As I like to note on this topic, how many railroads are on the monopoly board? 4. No coincidence. These examples are part of the larger pattern. Just last year, the Assistant Attorney General for Antitrust, Bill Baer, a lifelong antitrust practitioner, said his agency was reviewing deals with such serious antitrust concerns that they should never have made it out of the corporate boardroom. And there's reason for more concern, like the fact that 83% of companies that earned 25% profit or more in 2003 were still achieving those profit levels a decade later. Although firms may exploit an advantage in the short term, winners and losers should change over time in a competitive market. This should be the case in the American economy, or the fact that prices in America should be lower than other countries because the market is so large. But in general, American prices are not lower than in countries with smaller markets. All of this suggests that now more than ever we need vigorous antitrust enforcement, especially in light of the stakes. There are new types of activities to consider as well. Large institutional investors own almost 70% of the stock market. For example, the largest shareholders of Apple and Microsoft are BlackRock and Vanguard. We see this pattern in pharmacies, in soft drink producers, and banks. It's easy to see how this cross-ownership can hurt consumers. Many are also rightfully concerned that conditions the agencies place on mergers often fail and that more deals must be blocked. I can't tell you how many, say, content providers in the media market, other things, come to our offices, Mike Lee and mine. They cannot really, they don't really want to go public because they're afraid they're going to get screwed if they do it. But they tell us about what happens, that a lot of these merger conditions aren't being implemented, and in fact, they are not getting a good deal and not able to move forward despite the fact that some of these conditions were put on. So that's a big concern. The FTC disagrees, but I'm just looking at what I see, and I think it's a problem. And if it's not a problem, great, but you're going to see the proposal I have in a little bit to be able to create some kind of a check and balance promises that are made at mergers. As merger deals have grown, so often have the complexities of the settlements. We often talk about firms being too big to fail. A question for modern antitrust enforcement is whether some mergers are simply too big to fix. So here's the billion-dollar question. And I'm not using that number loosely since so many of these mergers are billion-dollar mergers. What are we going to do about this? One big question is obvious. More aggressive antitrust enforcement to prevent concentration and monopolies. Here's the good news. Antitrust and competition policies are not Republican or Democratic issues. They're consumer issues. They've tended to be more focused on by the Democratic Party, and I think that's important to note. I will say that Mike Lee and I, he's kind of a Tea Party background, have worked very well on these issues together and painstakingly work out ideas for conditions and other things when we send letters and work with the Antitrust Division, and they have told us repeatedly how helpful it is for them because, in fact, these are bipartisan suggestions on ideas for conditions and others. So we get now to the bad news. The federal government's commitment to antitrust enforcement has declined. Our economy, in terms of nominal GDP, has increased by over 20% between 2010 and 2016, and merger filings have increased by over 50%. At the same time, our antitrust agencies' budgets have been flat. Because antitrust agencies are only able to litigate cases involving the most highly concentrated market, they often can't deal with new issues, like the one I mentioned, and that's investment funds cross-ownership of competing firms within an industry. Still, these agencies are doing the best that they can, and we've seen some real results. In 2015, the Department of Justice obtained a record $3.6 billion in criminal antitrust fines. That probably surprises you, that number, $3.6 billion in fines. The Antitrust Division's entire operating budget is roughly 5% of that figure. What's incredible is that the division is actually a money maker. So if we have people that are interested in making money, this is one way to do it. The FTC has 6 antitrust cases in active litigation last year, including blocking Staples' proposed acquisition of Office Depot and 4 hospital mergers. And more recently, the Antitrust Division successfully litigated 2 mega mergers in the insurance industry, including Anthem and Cigna. Chairman Lee and I held an antitrust subcommittee hearing on the effects of those mergers on consumers. But we need the agencies to do more, and we need the new administration to take this seriously. Some might argue that President Trump, who has been both a plaintiff and a defendant in antitrust lawsuits, might be one that would champion increased enforcement efforts. We hope that will be true. So here's just a little fun fact for you to take away today. So he was both a plaintiff and a defendant. He was a plaintiff in the United States Football League's case against the NFL. In that capacity, Trump won damages. He won $1. It was tripled to $3. There is even an ESPN documentary about it. In 1988, however, he was on the other side. He paid a $750,000 penalty to settle claims that he had failed to make required filings with the FTC and DOJ in connection with an acquisition of stock in Holiday Corp and Bally Manufacturing. So overall, he's actually in the red on antitrust litigation. During the campaign as a candidate, his rhetoric actually echoed former President Teddy Roosevelt. He even talked about, quote, too much concentration of power in the hands of too few, end quote. But now it looks like the president is speaking a different language. I'll give you just a few examples. Early warning signs suggest that the Trump administration will appoint people who will scale back enforcement. Peter Thiel, one of the president's close advisors, has mocked free markets, saying, quote, competition is for losers. The acting chairwoman of the FTC has said that the Obama administration's more aggressive approach to competition, quote, imposed unnecessary costs on business, end quote. Here's another example. In a typical administration, the enforcement decisions of the Assistant Attorney General for Antitrust are made independently. The White House is typically not involved. But a meeting with the president-elect that occurred recently, where the CEOs of Bayer and Monsanto discussed their $66 billion merger, which is currently being reviewed by the Justice Department. We had a hearing, actually, in Judiciary on this merger, and a lot of concerns were raised. After the meeting, the administration took credit for commitments the companies made to create new jobs and invest in research and development. This was an uncharacteristic discussion and raises concerns that the president may want to negotiate merger settlements himself. After that meeting, I specifically asked Attorney General Sessions if he would defend the integrity and independence of the Antitrust Division. He said he would, and I will hold him to that commitment. That is just the beginning of Congress's responsibilities. Chairman Lee and I have developed a strong bipartisan approach, as I mentioned, to the committee. And this also means holding nominees to the Antitrust Division and the FTC to these same high standards. But I want to make one thing very clear here. It's not enough to prevent a deterioration of enforcement. In light of the broader impact of competition, the stakes are just too high to only play defense. That's why I'm announcing that I'll introduce in the coming weeks and months a package of bills with three goals. First is a check on merger conditions, the issue that I raised earlier. Effective enforcement depends on feedback. Agencies can make better enforcement decisions if they understand what has worked in the past, and this much is clear. We need to give the agencies the tools to check whether their efforts have been successful. I spoke earlier about the FTC's recent merger retrospective study, but it only covers FTC settlements, and it was the first study done since 1999. We have to do better, and this is what I propose. A better approach would be to require parties to provide information on a yearly basis after a settlement has been reached. Then agencies could easily review the effectiveness of past settlements, which would inform their future decisions. I believe we can design a requirement that both improves the effectiveness of antitrust enforcement without unduly burdening the companies who come before the government for merger approval. Second, we need better information. The FTC or the Department of Justice should be required to gather information about how investment fund ownership affects competition. Congress needs this information to understand whether there is a problem and when investment fund ownership is anti-competitive or benign. We need to understand how prevalent the problems are and whether current antitrust tools are sufficient to address them. Third, we need to up our game. Antitrust fees that are paid when companies file proposed mergers for review allow the government to exercise and pursue cases have not kept up with the times. In fact, the fee has not been adjusted since 2001, and parties involved in large deals are simply not paying their fair share. For example, each party is currently required to pay $280,000 for a deal valued at $807 million or more. But even deals of 100 times that size, I just used the Monsanto example, which demand greater resources for the government to review are stuck at that same fee. I propose two simple fixes. First, while we will take into account the burden on smaller companies by not increasing their fees, the fees should increase based on gross national product for everyone that comes before the Justice Department. Second, in an era of mega deals that reach tens or even hundreds of billions of dollars, we need a new category of fees that reflects the complexities of mega mergers and their serious impact on consumers. As one potential model, President Obama's 2017 budget would have doubled charges for deals over $1 billion. Even then, the changed amount would be less than 1% of the proposed value of the deal. These proposals are common sense solutions that will improve the lives of people across the country and also, by the way, improve capitalism. Capitalism is based on fair play and equal competition. It's based on this idea that you want to have a vibrant system where small companies can continue to compete and come into the market. If that competition is stifled, it's not only bad for consumers and for America, it is also bad for business. And so if any of the other reasons don't work here, I hope that will. All of this can be done. It doesn't take a miracle. It just simply takes a will to support our system that we have used so well in America, a system of free market, a system of checks and balances, a system where we put people first. Protecting competition speaks to the basic principles of economic opportunity and fairness. So as I said at the beginning, our goal is to make antitrust cool again. And if the administration won't do it, we will. Thank you.
Thank you. Laughter and antitrust. Thank you very much. It's fantastic. Thank you, Senator Klobuchar, for your remarks. The American people certainly are lucky to have an advocate like her in the Senate. She spoke passionately about the growing concentration of economic power in our country and how robust antitrust enforcement can help strengthen our economy. But the senator doesn't just talk the talk. She also walks the walk. It is a good reminder that we need to hold our elected officials accountable, not just for their words, but for their actions. And one of the most important actions that Trump has made so far has been to appoint Judge Gorsuch to the Supreme Court. Over the past decades, conservative activists, fueled by dark money, have targeted the Supreme Court to advance a pro-corporate political agenda that would never succeed through normal legislative or electoral process. Now, those same people and organizations are spending millions of dollars to promote Gorsuch's nomination. It's not hard to see why. His legal career consisted primarily of representing large corporations. Gorsuch has publicly argued that it should be harder for regular people to band together to hold Wall Street and huge corporations accountable for fraud and other wrongdoing. The broad question presented by this nomination is, will we allow the court to become a full-fledged promoter of pro-corporate, anti-consumer, anti-worker, anti-small business, anti-middle-class agenda for decades into the future? The answer to that question has critical implications for the relationship between money and power. Will America return to being a land of opportunity for all, or a place where the great concentrated powers shut out everyone else from the halls of Congress and even the ballot box? We at the Center for American Progress believe that the Senate should firmly reject Judge Gorsuch's nomination. But the Gorsuch nomination is not the only topic we hope to cover on our panel today. We are fortunate to host a distinguished group of experts to discuss the ways corporate and conservative assault on antitrust, administration, civil rights, and other laws impact the lives of everyday Americans, and what the Trump administration's approach and the Gorsuch nomination may mean for the future. To save time, I'm going to quickly introduce the panel now and encourage the moderator to jump right into questions. I'd also like to acknowledge the leadership of Andy Green and Michelle Jawando from our Econ and Legal Progress teams, respectively, for their work in putting the panel together. Elizabeth Wydra is the president of the Constitutional Accountability Center, where she brings a distinguished career as Supreme Court litigator to broader questions of what this Supreme Court means for America. Todd Cox, policy director of the NAACP Legal Defense Fund and former member of the Cap family. Well, I guess he is a member of the Cap family. He just doesn't work here anymore. Sure. You are a member of our family, is also one of our nation's most effective civil rights advocates. Deepak Gupta is founding principal of Gupta Wessler, one of the go-to litigators for consumer workers and ordinary Americans who have been wronged by concentrated power. Jonathan Cantor is a partner in the Antitrust Group at Paul Weiss and a leading thinker on antitrust law. And Lillian Salerno, former Deputy Undersecretary of Agriculture for Rural Development and one of the leading voices in the Obama administration for rural business and opportunity. Their discussion will begin momentarily, but first it's my pleasure to introduce our moderator, Sabeel Rahman. Sabeel is an assistant professor at Brooklyn Law School, where he teaches administrative and constitutional law. His new book, there it is, Democracy Against Domination, recently released by Oxford University Press, examines the tensions between economic regulation, new forms of private power, and ideals of democratic accountability in the context of the financial regulation debate. I should also note that the Constitutional Accountability Center has a new report on Gorsuch that is available by the door, and later this week, the Legal Defense Fund will release their report looking at his record. CAP's Legal Progress team also has an issue brief available on Gorsuch's record on corporate personhood. Please join me in welcoming Sabeel and our distinguished panelists to the stage.
Well, thanks so much to Winnie and to Senator Klobuchar and her staff, and to Andy and Cap and all of the panelists for this great discussion that we've already heard a lot, and we're going to hear a lot more. So, I think we have such a range of issues to get into. Maybe let me start with just a couple of broad points I think we'll see as a thread throughout the conversation. We've heard a little bit already today. The first is that a lot of the things we expect from an equitable, inclusive, and fair economy don't just happen, right? They're a product of law and policy. And what that means is that when you have concentrations of economic power unchecked by law and regulation, a lot of the things that we worry about get reproduced. Exclusion, inequality, lack of access to opportunity, lack of accountability. And I think these are themes that each of our speakers are going to raise in different ways. And so, Jonathan, maybe we can start with you. We heard from the senator about the importance of merger enforcement. Maybe you can give us a bit of a broader view about antitrust law, the landscape, and kind of how we got to this point where we have this big problem of economic concentration.
Sure, and thanks again for having me. I was definitely extremely heartened by the comments from Senator Klobuchar. Klobuchar, bringing much needed attention onto this issue and really distilling many of the core concepts down to a very accessible level, one that makes a lot of sense and common sense. I also am grateful for her equating antitrust with cool, because now I can go home and tell my 12-year-old and my 9-year-old who think I'm extraordinarily uncool, that I'm associated with something that's hip. So how did we get here? And Senator Klobuchar discussed this, but we really saw, to some degree, a revolution in the 70s. Led by Judge Posner, Robert Bork. And that was to take antitrust and transform it. Transform it from a discipline that focused on addressing concentration of power, not just because it's good for prices, because it's good for our economy and democracy more generally. And really transforming it into something that was almost singularly focused on what they call consumer welfare or price being the only objective of antitrust law. And over the years, 70s, 80s till today, we now have a world where antitrust has been narrowed substantially in terms of what it considers. It's focused, again, almost singularly on price effects, to the exclusion, in many instances, of competition, innovation, and the effect on our democracy more broadly. There's a lot of discussion around mergers in the context of antitrust, but in thinking about the impact of the nomination of Judge Gorsuch and trying to understand where that might lead in terms of antitrust, I can't help but stop and think about the other aspects of the antitrust law, the Sherman Act, Section 2 specifically. So if you think about the root of the antitrust laws, they come from railroads and oil companies and these clogging the arteries of competition, and what that means for our society. And it's interesting because in an era where we have perhaps more concentration than we've ever seen, the consequences for abusing that position once you achieve dominance, the consequences are about as low as we've ever seen them. And in large part, that's because there's really under-enforcement of what they call Section 2 of the Sherman Act, monopolization cases. And the root of that is one from both a political agenda, but it's also a Supreme Court. And the Supreme Court over the last 20 years has really eroded, based on this thinking from the 70s, has eroded what's possible in terms of bringing cases against dominant companies that abuse their market power. And so there are cases, and people will throw them out, not to bore folks with legal cases, but Trinco and Linkline and a number of others have really eroded what courts and agencies consider when examining anti-competitive conduct or allegations of anti-competitive conduct. I can't tell you how many times I've been in front of the agencies and talked to them about cases where a company might be abusing its market power, and there's this view of the world that so long as you've achieved that market power lawfully, you can then use it any way you want with very few consequences. And this is an issue. And if you go back, and perhaps no single case at the Supreme Court has done more damage to this than the Trinco case. And in looking at Judge Gorsuch's opinions, first it's important to help put it in perspective. He's an antitrust professor, so in some instances you might look at opinions of judges who are nominated to try to understand and read the tea leaves as to where they might come out. And sometimes there's a temptation to overread, especially if they had clerks with one position, or there was an issue that they weren't steeped in and they were just trying to cut surface deep. But if looking at just the small number of opinions by Judge Gorsuch, he's somebody who understands antitrust. He teaches it. The other piece is that, at least for me, in trying to understand the tea leaves, he talks about aspects of Supreme Court cases and in many respects amplifies this sort of narrow scope of monopolization and enforcement. There's a lot of debate in antitrust communities about the impact of cases like Trinco, and really what they mean legally, right? There's a lot of language in there that's not necessarily binding. They call dicta that you don't have to follow, suggestions, and then there's the real legal holding. A lot of the opinions by Judge Gorsuch focus on the dicta, the non-binding aspects of the opinions, but treat them as if they're absolute black letter law, and reaffirm them and back them up with principles that are really embodied by what Senator Klobuchar referred to as that Bork frame from the 1970s. And so if you look at those opinions, it does not necessarily suggest that we're going to see a change in what's legally possible at the Supreme Court. But if anything, we might see a reinforcing or a doubling down of the precedent that's come down over the last 20 years. And for someone who might be pro-enforcement, that should be concerning.
So that's super helpful, and I think you're giving us a sense that there's the risk here, or one of the risks here, is that Judge Gorsuch could as on the bench, could continue to narrow the boundaries of what antitrust law covers, which then makes it harder for competitors and other actors to hold those market-dominant players accountable through the courts and through litigation. So to get a sense of the implications of that, right? Lillian, I want to bring you into the conversation. I wonder if you could talk a little bit about how you see this problem of concentration and lack of accountability for large market-dominant corporate actors, how that affects economic opportunity from, as you've seen it in your experience.
Sure. And thank you. And I think this is such an important opportunity I'm someone from rural America. I am that endangered species called a rural manufacturer, and I know what it's like to put together a company and try to sell your products and get the investment to do that, hire the folks to do it, and then find out that there really isn't an open market for the products that you sell. For many years before I was an Obama appointee, I used to come to Washington in the 90s and the early 2000s and go to the federal agencies and go up on the Hill just as a founder of a small manufacturing company. And I was always, as a non-Washington D.C. person from rural Texas, I was always surprised that there was this, seemed like a morph almost, of every time I would present the case or present the obstacles, it was this idea, big is better, pricing. It's all about pricing. If we can get the consumers pricing, that's what we're interested in. And I'm thinking to myself, what about innovation? What about, opportunities for small business? And there was always this, I don't know what happened. I'm not a legal scholar. I'm a lawyer, but I'm not a legal scholar, and certainly not on antitrust. But what I am is a small business advocate and a rural manufacturing advocate. And there just seems to be some kind of a morph that happened where there was this crazy idea that if you had a bigger, that the prices would come down. And I think it's just sort of, I didn't have a great education in rural Texas, but I knew one thing. Costs are one thing, price is another. And when you do volumes, yes, your costs come down. That has nothing to do with price. And so we sold products in the marketplace and were wholesale rejected in the industry we're in. And when I got to have this opportunity to join the Obama administration in the ag world, where we also have these huge concentrations of power in the hands of a few, I thought, maybe it's different. Maybe the agencies have the resources they need. Maybe there's an opportunity to talk about it. And what I found after literally visiting hundreds of small farmers and small businesses across the country, mostly in rural areas, that they had the same problems. And at first I thought, maybe I'm looking through my prism, maybe I'm listening to my own self and I'm not listening to them. But for sure, when I heard those stories, about folks trying to sell when there was only one buyer. That's a problem. And I heard stories of these unforgiving obstacles in anti-competitive logistics of distribution, anti-competitive, distribution and methodologies about pricing and bundling, market manipulation, what people do in the trade association or trade group world where the little guys don't have a seat at the table, so the regs are made by the big guys. And sometimes, many times I checked myself in my 5 years thinking, maybe I'm not the best person to know this because I lived it. But then the number two, or the person in charge of capital markets at SBA, who I'd never met before, she and I just happened to testify at a hearing for the Small Business Committee on duplication or something like that. And after the hearing, she said, you over at USDA, do you guys ever collect data that when businesses fail or when you can't give them a loan, what the reason is? And I said, yeah, we've got some kind of form that asks that for farmers and for small businesses, but no one's really tracked it. And the defaults, we have a whole range of reasons, and no one's really, looking into it. And she said that in her experience, and her name's Anne Marie Mellum, and she had been an independent banker in Oregon, and she was head of capital markets at SBA. She said, independent of me, what I saw for businesses trying to get loans and what I see in my role at SBA is that there's just concentration of power makes it, we can't give them money, we don't know where they're going to sell to. I can't loan them. And when they default, it's because somebody's bought or compiled a bunch of folks and they've got one buyer. And she said, we really have to do something about it. And I said, yeah, we should. We should talk to the government. And we both sort of laughed and said, we are the government. And so we told this story, and we looked at opportunities. And actually, I know it's about resources with some of the federal agencies that this is on their watch. But as a former Obama official, I did go to the NEC, I did go to the FTC, we did talk to the White House, we did talk to folks on the Hill saying, we are the officials for the small business in this country where you think every day of ways to increase competitiveness, increase entrepreneurship, increase business startups, and all of this is going on, and your 500-pound gorilla that's keeping it down, we can't do anything about. You have to do something about. And we requested at least look at some data, at least find out what we could do, some immediate actions, because everyone in this country is so worried about manufacturing. We have czars of manufacturing. We have the Commerce Department, the SBA, and the NEC, and the USDA, and a host of other agencies looking at this problem, and it just seems like there's this underlying deal that people think big is better, or that we've been cajoled into that big is good for consumers. And the government is here to protect the consumer, and that pricing piece is so important. And this is while Congress and agencies are trying everything they can do to do entrepreneurship and small business startups. And of course, just as the senator said, it's not a Republican or Democrat problem. This inability to correct this causes real problems. I talk to entrepreneurs in my private life and my work life every day. When I wake up, I think of myself as an entrepreneur, and I think it's really scary right now. We've got to make it an environment where people are out there knowing that it's a reasonable thing to go out there and start a small business. I know what happened in my own industry and in agriculture. How can you possibly get capital when folks have treasure troves of capital that they don't have to invest in marketing, and you're supposed to compete with them? If it was a competitive market, these big, large institutions and monopolies wouldn't have trillions of dollars in their coffers. They'd be out there competing. Just let small business get on the track, and we can compete. But without fixing this problem, we're really we've got serious issues.
That's great. So the ripple effects here of market concentration extend much beyond the impacts on consumers and prices, right? It's really affecting the viability of a whole range of businesses and economic activity and dynamism that we sort of expect of a inclusive and innovative economy. So that's kind of both Jonathan and Lillian kind of giving us a sense of the implications of antitrust sort of proper competition policy and market concentration. But these same kinds of dynamics, Deepak, you've written a lot and argued a lot about how these similar problems of concentrated economic power and influence affect the scope of redistribution, wealth transfer, and the difficulties of ordinary people, communities, small businesses to hold those private actors accountable. And so if you could speak a little bit about sort of from your work how it's been so difficult to respond to the kind of challenges that Jonathan and Lillian have laid out.
Sure. Yeah, I'm really glad that the Center for American Progress is having this conversation, because I think too often when people think about what the Supreme Court is up to, or maybe what the government is up to in general, they're focused on hot button, social controversies. But in my view, the effect that the court really has that people should really be paying attention to is the way it affects kitchen table issues, their pocketbook. And the questions that we're talking about, they can seem very technical. I mean, if you stop someone on the street and you ask them their views on antitrust law, they may not think that they have views. But I actually think that, ordinary Americans understand that the economy is increasingly stacked against them. They understand that there's rising economic inequality. They understand that they don't have a fair shot in the same way that they thought they had. And what I would like people to understand, and what I'd like to inject into the conversation, is that the law is part of that. The law both relies upon, I know you've written a lot about this, the law both relies upon and facilitates these kinds of trends, and people should be concerned about that, both when they're thinking about who to vote for and what might happen with this next Supreme Court nomination. And so what I want to focus on is how the law gets enforced, because it doesn't matter what the law says if you can't enforce it, right? There's a congressman that famously said, you write the substance, I'll write the procedure, and I'll screw you every time. And what he meant by that is that, if I get to write the procedures about how you get to enforce the law, that's where where the rubber meets the road. And the conservatives on the Supreme Court and their allies in the Chamber of Commerce and other groups have recognized this and have pushed a radical agenda on the court that has limited the ability of ordinary Americans to enforce their rights. And unfortunately, without people really noticing it, without them recognizing it, because it relies on these sort of technical legal concepts that don't get as much attention